we'll go to talk about the module D. In module D, we are talking about commercial laws today. Normally, when you look at the various laws enacted by the government, we broadly bifurcate them into three. One is commercial laws, second is industrial laws, third are general laws. General laws like Banking Regulation Act, these are all the general laws. Industrial Dispute Act, Trade Union Act, these are all the industrial acts. Other things which are relating to Indian Contract Act, Sale of Goods Act, these are all relating to the Commercial Act, Commercial Services and Commercial Act. In this particular module T, we have units from 25 to 34. Here we are also talking something about the commercial laws and also general laws also. These things like Indian Contract Act, Sale of Goods Act are in fact commercial laws. The Partnership Act, Companies Act, LLP Act, etc. general laws. Transfer of properties again is a commercial law. Right to information, these are all general laws, but they combine everything. So we'll discuss one by one with reference to these acts and this particular module T. First, we start with the Indian Contract Act 1872, Unit 25. This particular Indian Contract Act has two important segments. One is general principles and second is special types of contracts. In general principles, the Contract Act speaks about how a contract has to be made, what are the prerequisites of maintaining a contract, and what are void contracts, which parties can contract, which parties are eligible to enter into a contract, what are the various obligations of the parties for a contract. All these related general issues are discussed in the general principles in this particular Indian Contract Act. The Act also speaks about certain special contracts which are executed between the two parties, like indemnity, guarantee, agency, bailment, and pledge. These are the 5 special contracts which are also given under this Indian Contract Act. First of all, we will see what are the general principles and then what are the special types of contracts. The first one is that Section 2 of the particular Indian Contract Act speaks about what is a contract. Before we would like to define what is a contract, we should always, or anything we call it as a contract, 4 things precede the contract. First one is a proposal, second one is a promise, third one is a consideration, and fourth one is an agreement. Proposal, promise, consideration, and agreement. We'll give an example. A customer comes to us and he wants to open a savings bank account. Then he fills up the application form, gives us his proposal, intended to open an account with us. This is the proposal. He has given us a proposal. Once that proposal has been given to us, we will verify whether the customer can open an account with the bank or not. As per the KYC guidelines or whatever we call that, first we will verify. If they are acceptable to us, we promise to open an account. So 2 things have been done. One, the proposal has been given by the customer, the person who is intending to open the account, and I accepted that proposal and I promised it. Okay, I'll open the account for you. Then once we convey our promise, the proposer has to make payment to the payment for opening the account. That's called consideration. Consideration is always basically in terms of commercial transaction. So consideration means, okay, he agrees to make payment and he makes a payment. Then once he makes a payment, it converts into an agreement. Once an agreement has been entered into between both the parties, it should be signed by it could be even oral or it could be signed also. Normally when in the savings bank account, when the rules are signed by there is one page where the savings bank rules are there. When he signs that, it becomes an agreement between the bank and the customer. Okay? Bank and the customer. Now, if that agreement is, binding under law or its agreement is enforceable under law, then only it becomes a contract. Okay? Then only it becomes a contract. So once it becomes a contract, then there is a relationship between the account holder and the bank. So a relationship is established once the contract is entered into. Contract will be entered only when an agreement is enforceable by law. And agreement is possible only when there is a consideration by the party. And consideration is only possible when the promisor has agreed to do that on the proposal given by the customer. So proposal, promise, consideration, agreement will only lead to a contract provided it is enforceable by law. So there are certain contracts which are not enforceable by law. What are those contracts? Some of things we will also see in the subsequent slide, which contracts are void contracts. And now here we can give one corollary. All contracts are agreements. All contracts are agreements, but all agreements do not become a contract. All agreements do not become a contract. This is also one corollary we will take out. So then what are the things in a contract? What are the essentials of a valid contract? Then we will see what are not a valid contract. Secondly, if any contract is considered as a void contract or a contract not enforceable by law, it is invalid from the beginning itself. From the date it has been signed, it becomes invalid. So once it's a valid contract, it is enforceable from the day one when both the parties agrees to the agreement. So they say contract is always between two parties. Party one or two parties or more than two parties also. Let's suppose we are opening a joint account. Then the contract is between more than two parties, bank one side and the customers on the other side. This is one. And whenever the contract is made, basically it should have lawful consideration and lawful object also. Okay, what is a lawful object? What is a lawful consideration? We'll also see. Then the offer should be certain and the promise should also be certain. The consideration should also be certain. Okay, and everything has to be documented properly. Certain agreements need registration. All agreements may not require registration. Some agreements may need registration. Some agreements may also need to be stamped as per the concerned state act or maybe central act. Then only they become legally enforceable contracts. Then only legally enforceable contracts. Then, when the contract is being executed between the two parties, they must be competent to enter into such contract. Especially these two people, minors or people of unsound mind, or even people who are declared themselves insolvency, they are not entitled to enter into contract unless their IP has been approved by the court. Okay, so if we are entering into any contract with a minor, that itself is a void contract. And let's suppose we entered into a contract today with a minor. Then after 1 month, 2 months, we come to know that with whom we entered into a contract is a minor. Then whatever transactions we do from day one, when we entered into all those transactions will become null and void. So that's another point they say in the beginning. Here say a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Okay. So here, of course, this is talking about the void contract. Till that time, till we come to know that the parties are entitled to do that. If some transactions are done by ignorance of the hidden mistake, hidden what you call the mistake in the system, they are enforceable. Thereafter, they do not become enforceable. So especially any contract we make with minors or men of unsound mind are not treated as a valid contracts under section 11. What is a valid contract? What is an invalid contract? Secondly, a contract should always be absolute and there should be unconditional acceptance. Let us suppose if I do this, I will do that. If I do that, I will do this. If such conditions are laid down in the contract, then we cannot consider it as a proper agreement enforceable by law. No conditions are attached. Okay. Another is in any contract, consideration is very, very important. Consideration is very important. What is consideration? A financial consideration between both the parties. When we are opening a savings bank account for the customer is depositing money into that. That's a basic consideration what is going to happen. But in certain contracts, consideration is not mandatory. For example, if somebody has given as a gift, then there's no consideration necessary. Okay? There's no consideration necessary. For example, somebody gets a property by legacy, an inheritance, then there's no money consideration there. And even though there's no consideration from the other party, even such consideration is also acceptable consideration, but only requires a registration. If we wanted to make that consideration as a valid agreement, then we need to register such kind of things. Secondly, when these gifts are given, it should be between the close parties only. Near relation will always say. Secondly, fulfillment of voluntary promise are under legal compulsions and time-barred debts. The time-barred debts we had discussed in the limitation period. Whenever with the borrower is executing fresh set of documents or entering into fresh agreements for the debt which he has already time-barred, then there is no consideration there. Means when he's executing fresh set of documents, bank is not giving any fresh loan to him. Even though there is no consideration there, then it's also treated as a valid agreement and valid contract. Contract of agency does not require any kind of consideration. What is agency? We'll discuss in the special contracts. So it's not necessary that consideration is mandatory in all the contracts. But in which contracts the consideration is not necessary? Where the money, where the where the but where the where the other party is receiving it either as a gift or a legacy or inheritance, or is giving accepting something which has been done in the past, even though it is barred by limitation. And the third one is that in the case of agency contracts, consideration is not required. Another thing is that which contracts are void. Some contracts we have seen about the parties. For example, if minors, then men of unsound mind or people of unsound mind, then any contract we are entering into them becomes a void contract. That's what we know. For example, we entered into a contract with a person, he is of sound mind. After 2 months, 3 months, or 5 months, suddenly we come to know he became a man of unsound mind. Then any contracts we conduct thereafter will become voidable and we cannot enter into any contract with him. But there are also certain contracts which have been given in the particular act which are void itself. Some of these things you can see. Agreement in restraint of marriage of any person other than minor. Let's suppose somebody entered into a contract. I go to a person and say my son is marrying that girl. You restrain him marrying that boy to that girl. Okay. Then I enter into a contract. I made a proposal. The person is agreed to perform the thing. And I also paid him some money to do this. So it becomes an agreement. And whether that agreement which I entered into, whether it is enforceable by law, so it cannot become a contract. It becomes an agreement. Up to the stage of agreement, all these things can be done. But what will happen whether it's a contract? If it has to be contract, it has to be legally binding. But what Section 26 says, if I'm restraining the marriage of my major son, then it cannot be treated as that such of contract is treated as a void contract. Let us suppose my minor son is marrying. Then if I restrain that marriage and give a contract to someone, then it could be treated as a valid contract. Okay. So like that, there are different things where certain contracts are void as per the act. Okay, they have listed out professional or trade, legal proceedings, uncertain agreements, agreement of wages, gambling. These are all activities which do not form a contract and they become ab initio. All the above categories of contracts are void ab initio. From the beginning itself, they will become void. Whereas, I think I will bring this distinction once again. If any contract has been made, which is under these sections, they become void from the time we make a contract. In the case of another areas, void contracts, if we come to know about the person who is incompetent to contract, okay, from the time we come to know, then that becomes a void contract. till that time, whatever contracts they have been entered into, they become applicable. For example, we entered into a contract with a minor. We do not know he's a minor, and we entered into a contract. Both of us, myself and the minor, has conducted certain transactions about 4 5 months. Suddenly, on the fifth month, I came to know that he's a minor, and could not. My contract with him is a void contract. But what are the actions that had taken place between the from the initiation of the contract till I came to know about his incompetency to contract? Those transactions need to be complied with by both the parties. Once having known that, then I cannot do it further. But whereas void agreements, what they are speaking about here, which is some conditions are attached here, then these become void from the beginning itself and not from the time we come to know about the contract. That's the distinction between void contracts under these sections and void contracts when we are entering with a persons to the contract. These are all the important things with reference to general contracts. Some of the slides which are normal in nature, I did not discuss them. Otherwise, it also contains some more slides. For example, there is one more also. Any contract entered into under social or religious obligations are not treated as contract. For example, normally a question arises whether a marriage is a contract under the Indian Contract Act, whether marriage between a man and a woman, whether can it be considered as a contract under Indian Contract Act. What is your take on this? Whether a marriage is a contract under Indian Contract Act? Yeah. Indian Contract Act exempts social and religious contracts as void under Indian Contract Act. Void means they are not considered as contracts under the Indian Contract Act. So the marriage between a man and a woman are not treated as a contract under Indian Contract Act. In some slide it was there. I think the slide was not shown here. It is there. Okay. Now we are going to look at some special contracts which are given in the Indian Contract Act. First one is indemnity and guarantee. Both we will be considering it. Indemnity is, there are two parties to an indemnity, indemnifier and indemnified. Indemnifier and indemnified. If any indemnified approaches any person to compensate him in case a loss is occurred to him, as per the conditions laid down thereon, the indemnifier has to make good that loss to the indemnified. This is called contract of indemnity. One example we can give is insurance policy. Insurance policy is a contract of indemnity. Which insurance policy? General insurance policy is a contract of indemnity. Okay? Not the life insurance. Life insurance is not a contract of indemnity. It's a general contract. So in contract of indemnity, what we are doing when we take an insurance policy, we are going to an insurance company and then we are asking to insure a vehicle, and if any certain events mentioned in that contract happen, then the indemnifier means the insurance company has to compensate the indemnified. Let us suppose the events stipulated in the policy do not happen, then the indemnified has no right to claim any money from the indemnifier. So this is what the contract of indemnity speaks about that. That's why I say a contract by which one party promises, who is promising? Insurance company is promising to save the other from loss caused to him by the conduct of the promisor himself or by the conduct of any other person is called a contract of indemnity. So one is that what are the losses? What are the events that losses are to be covered? Has to be clearly spelled out in the indemnity bond or indemnity letter. Secondly, only if such losses are only happening, then indemnifier will pay, and then indemnifier will not pay. Okay, these are some conditions with reference to indemnity. One party promises to save other from loss. Loss can be from conduct of promisor himself or another person. Promisor is called indemnifier and indemnified. The received must prove a loss. Means the indemnified has to prove a loss because of some acts which have been mentioned in the policy or the agreement. A contract indemnity may be express or implied. Is express or implied. Some are implied situations. Some could be expressly written also. That's why we write. Some of the guidelines given above are not exhaustive, only illustrative. That's what we write. Means everything cannot be put in black and white. Some of things are implied by the contracts. This is called contract of indemnity. Now, so insurance policy, the contract of indemnity can say this contract of indemnity is applicable to the banks also. We take indemnity in the case when we issue duplicate FDR, DDR, PR, etc., or whenever we are settling claims in the case of deceased customers. Okay. Normally, whenever we are taking an indemnity for the settlement of claims in case of deceased accounts, indemnity has to be taken only in the case of where settlement is taking place of legal heirs. If the settlement is taking place in the name of nominees, we need not obtain any indemnity. We may obtain general letter, but no indemnity required. Why? Because when we are making payment to a nominee, bank has to identify the nominee, and bank is responsible in identifying it. If they have not properly identified the nominee, and they are responsible for the loss and not that person who received the payment. Whereas in the case of legal aids, when they are asking, when the payment is made to them, legal aids themselves have come and told, we are the legal aids. So let us suppose any other person comes thereafter and he says, I am also the legal aid and is proved to be true by the court of law, then the bank having paid the money to wrong legal aids need to be compensated by the persons to whom we paid the payment. That is why indemnity is always taken in case when the settlements are made to the legal heirs and not to the nominees. So these are the two. Sometimes some banks are also taking nominee for indemnity in the case of loss of passbook, issuing a duplicate passbook, etc., etc. Also, all these the indemnities need to be stamped as in agreements. And whenever we are putting the stamp duty on this the indemnity, these indemnities, and they are the stamp duties as per the concerned state government. Different states have different stamp duties to be taken on the agreements. Secondly, no point of time these indemnities should be witnessed by anyone. If they are witnessed, they are treated as a bond, and ad valorem stamp duty has to be paid. For example, we have issued a demand draft for 1 lakh rupees and the customer has asked us to give us a duplicate demand draft. Then we have taken an indemnity from the customer. The indemnity has to be stamped as an agreement. For example, in the state of Andhra Pradesh or Telangana, agreement attracts a stamp duty of 100 rupees. So we'll put a 100 rupees stamp duty and then we take the agreement. Let's suppose that agreement has been witnessed by some people, maybe one or two witnesses the agreement, then the stamp duty payable is not 100 rupees, it is ad valorem duty, normally 5% or 1 point, whatever is the percentage. Let's suppose even 5% is there, then stamp duty payable on that indemnity is 500 rupees. So that is why wherever we are taking indemnities, they should not be witnessed by any other party. So these are the cases where we are taking indemnity, and those are the conditions with reference to indemnity. One is that the indemnified has to prove the loss, and if this loss is payable as per the guideline, as per the policy agreement between both the parties, then only payable. Otherwise, they are not payable. Any loss incurred. Okay, so that's why we say the all general insurance policies are the policies given under as a indemnity. Next one, you have any questions on indemnity, sir? Or should I move to the contract of guarantee? Now, we talk about the contract of guarantee again. Again, this contract of guarantee we can discuss from the two points. One is the guarantees we take in the case of borrowing accounts, and second is the guarantees we give on behalf of the customers or applicants. Two types. Both the things are covered under this contract of guarantee. Now here, what is this contract of guarantee? It is defined in the Indian Act. Contract of guarantee is a contract to perform the promise or discharge the liability of third person in case of his default. Now there is a word called third person. Means there are three people involved in a guarantee. Indemnity, only two people are involved, indemnifier and indemnified, whereas in a contract guarantee, three parties are involved. Simple example we'll give, then we can discuss the parties. Let's suppose we have given a loan to a borrower. Then there is a contract between bank and the borrower. Okay, because we have given a loan, we entered into a contract. There is a creditor-debtor relationship between the bank and the borrower. Now, we also take a guarantee from another person. Means another person. Why we are taking the guarantee from another person? In case the borrower does not repay, the bank has a right to recover the money from the guarantor. With third party. That third party is called a guarantor. So this situation arises only when the borrower does not repay and have a right to claim the money from the guarantor. So here three parties are involved. One is the bank, the creditor, the borrower, debtor, and third person who guaranteed the loan. Okay, three guaranteed the loan. So, in case the borrower does not pay, only the liability of the guarantor arises. This is one. If the borrower regularly pays, then guarantor is discharged of his liability. This is normally what we take about contract of guarantee when the banks are lending money to the borrowers. We also execute guarantees in favor of the beneficiaries at the request of the applicant. For example, there is a retailer who is buying goods from a wholesaler. We'll take one example. There is an electronic shop who is purchasing regularly the maybe TV sets or refrigerators or maybe the washing machines from Samsung company. There's a contract between Samsung company and this retailer that the Samsung will supply the goods regularly and he will make the payment to them. So this process has been going for quite some time. Sometimes the Samsung company will have a doubt. I am supplying the goods to the retailer and is paying the payment to me very good. But if it doesn't pay the money, then what will happen to me? Then the Samsung will have a problem to recover the money. If he's not paying the money, then how will be able to recover the money? And Samsung must be entering into such contracts with several retailers across the country. So if 10-15 people default like that, then Samsung's business transactions itself will be affected. That's why what Samsung will say to the borrower, to his retail dealer, he says, go to your bank and obtain me a guarantee. And what is that guarantee says? In case tomorrow you fail to make any payment to me, means the Samsung says, in case you make any payment to me as per the schedule, I will demand the payment from your bank. And bank should make the payment to me without any riders attached to that. This in case the applicant approaches us, once the retailer approaches us and we give such a guarantee to the Samsung company, that is treated as a contract of guarantee. Here, in the contract of guarantee, non-performance is very, very important. And whose side the non-performance is there? From the applicant side, there is a non-performance. Then the beneficiary can claim the money directly from the person who has given the surety or who has given the guarantee. So in this case, the bank is the guarantor and they have to make the payment to the beneficiary, that is the Samsung company, in case a default has been told by the Samsung company to us. So this is called contract guarantee, which we normally gives guarantees to many customers. Here also the contract same, three parties are there. The principal debtor is the applicant, creditor is the beneficiary, and surety is the bank. Okay. Hope you know these guarantees, and this is what the guarantees will work out.